Hello, this is Matt on the Moon Family Sedan channel. Attorney John Deaton today filed 612 pages to the court directly to Judge Torres, who will determine the outcome in the SEC v. Ripple case. Now, 39 pages of that was the amicus brief. Now, mind you, I've already covered that pretty thoroughly on the channel previously, so I'm not going to run through that, but let me tell you this. There's, I believe it was 573 pages of exhibits. I am so impressed. Attorney John Deaton is making damn sure that Judge Torres is more than sufficiently armed with knowledge. She's going to know, if she hasn't read everything already, she's going to know everything that you and I know. And that's powerful. To see how crooked all this is and how the SEC has been approaching the SEC v. Ripple case, first under Chair Jay Clayton, and then under Kim Jong-Gensler, is some bad stuff. So I'm going to share with you some of the stuff that Attorney John Deaton included as exhibits. My gosh, it's thorough. I mean, well, you would expect that with 573 pages. That's why when I looked at that, I was like, oh my God, this is the biggest document I've opened since this case started almost 2 years ago. It's the biggest legal document that I ever opened. I was like, well, good thing I didn't accidentally hit print, because I ate print over a ream of paper, 573 pages. But I am going to share with you some key portions on this and share with you some thoughts along the way. Before going further, though, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so here it is. Here's a tweet from Attorney John Deaton just this evening. And this is a quote, because he had just shared from his Crypto Law Organization's Twitter page that these documents had officially been uploaded to the Crypto Law website. And then he quoted as follows: Amici Curiae respectfully submit this brief because if the SEC is successful in its claims against XRP, the SEC would have the authority to regulate a vast number of non-parties, including digital asset exchanges, developers, vendors, and ordinary users and holders of XRP. This would dramatically affect the entire secondary market for XRP and possibly the entire cryptocurrency market. While the SEC uses this enforcement action as a test case for expanding its jurisdictional reach, millions of innocent holders suffer the harm. End quote. And so that's directly from the amicus brief, and that's powerful. So I thought I'd share that here. But because that is a snippet that Attorney John Deaton even shared right here. But again, I'm not going to go through the amicus brief again. I already did it. But my gosh, you got to see this extra stuff that he shared. And I won't pretend to have read 573 freaking pages. But I've run through enough that I can see exactly where Attorney Deaton's going with this. I just haven't seen anything like this in this case. And I think I've opened probably, unless I somehow magically missed something, I think I've opened every single legal brief, everything that's ever been filed publicly. I think I've opened it and looked at it. So when I saw this again, I was like, oh, mama, this is some cool stuff here. In a separate tweet, Attorney John Deaton also wrote, and this is from this morning, XRP holders brief shows the judge the true perspective of an XRP holder. Our amicus brief is in opposition to the SEC's motion, not in support of Ripple. I do ask the judge to grant Ripple's motion because no reasonable jury could conclude secondary market XRP sales are securities. So take a look at this. I mean, for those of you looking at the screen, look at the number of exhibits. I'll just kind of scroll through here, and I highlighted in my tabs. You'll see I'm going to go through. I highlighted a bunch of them, not literally all of them, but my gosh, like he went through every letter in the alphabet. And then he started looping that because there's Exhibit A, Exhibit B, Exhibit C, so on and so forth through the end of the alphabet. And then he comes back with Exhibit AA, Exhibit BB, Exhibit CC, because there's so much in here. I absolutely love this. This is awesome stuff, as you can see as I'm scrolling through this. But let me start with this. I'm not going to read this whole thing. I've talked about this on this channel a number of times, but I don't know how many of you have actually seen this whole letter. I'm not going to read the whole thing, but there are a couple key parts I want to highlight. This is a letter from Joseph Grunfest, who was an SEC commissioner. And again, as a friendly reminder, the SEC commissioners are the ones who vote on whether or not to bring legal actions against any person or business, nonprofit, whatever it may be. and there are 5 votes total. He used to be one of them, and that was back in the 80s. And here you can see this letter was dated December 17th, 2020. So this letter is 5 days, was written 5 days before the SEC actually sued Ripple. But as it turns out, Joseph Grunfest had caught wind through his connections that this was going to happen, and he wrote a long letter saying, hey, this should not occur. This letter is included as an exhibit by Attorney John Deaton. So again, like, I'm not kidding. This is why I was so happy to see this. Nobody else has done this. Nobody else has done this, what Attorney John Deaton did here. She's just spoon feeding Judge Torres everything that she needs to know to come to the proper conclusion. And so I want to share with you just part of this, because this really is powerful stuff. And again, this was written by Joseph Grunfest 5 days before the suit, and he was against the SEC suing Ripple, claiming that XRP is an unregistered security. In fact, he believes XRP is not a security. But take a look at this part. I'm going to read just a snippet. Oh, there are a couple snippets, but I'm going to start with this one right here. The contemplated enforcement proceedings alleges no fraud, misrepresentation, or omission, but simply initiating the action will impose substantial harm on innocent holders of XRP, regardless of the ultimate resolution. Upon learning of the proceeding, intermediaries will cease transacting in XRP because of the associated legal risk. The resulting reduction in liquidity will cause XRP's value to decline. XRP's aggregate market capitalization as of December 16th, 2020, was approximately $23.8 billion, making it the 3rd largest form of cryptocurrency in the world. Given the significance of liquidity to the XRP market, the withdrawal of intermediaries will most likely cause billions of dollars of losses to innocent third-party holders. This result would, to my knowledge, be unprecedented. I am aware of no instance in which the simple announcement of a commission enforcement proceeding has, absent allegations of fraud, misrepresentation, or omission, caused multi-billion-dollar losses to innocent third parties. Creating precedent and imposing losses of this sort raises public policy concerns that would benefit from the views of an incoming administration. So I'll just pause right there. Amen, hallelujah. That is exactly right. It's spot on. And that prick Jay Clayton didn't give a damn. He just wanted to do what he wanted to do since he was on the way out the door. Since there's a new administration coming into the United States, that was his last chance to go ahead and sue. I don't even think that he was ready. Outside of an administration change, I don't think we would have seen that lawsuit, at least not on that date. But that's why we saw it. He just wanted to do it. He just threw a metaphorical bomb and was like, bye, Felicia. And then he just exited stage left. That's what that prick Jay Clayton did. And he knew that was going to happen. And indeed, it was about $15 billion in terms of market cap that just went poof. Practically overnight. And take a look at this too. I love this. He also wrote, the staff has articulated no material distinction between the operation of Ether and of XRP that is relevant to the application of the federal securities laws. Imposing securities law obligations on XRP while leaving Ether untouched raises fundamental fairness questions about the exercise of commission discretion. Oh my God, folks. Again, and this is a former SEC commissioner. The judge will see this if she's not yet. It's an exhibit. It's here. It's in Attorney John Deaton's amicus brief as an exhibit. I love this. Let me show you some more stuff that is attached here. Take a look at this. I know it's sideways right here, but whatever. I'll just read it to you. I gotta cock my head a little bit to read this. So this is an advertisement from Coinbase, because Attorney Deaton has argued that it may perhaps be the case that Coinbase has really promoted XRP more than Ripple. And if you think about it, Ripple, to any degree that they're even promoting XRP, would be to, basically institutional partners, key strategic partners who are businesses, not retail. And here you have Coinbase touting it specifically to retail speculators and holders. And so look at this. It reads as follows: send money internationally for free. And then they got a little check mark here. Which is the same as a bullet point. That's the purpose of it here. It says fast. Send money across borders virtually instantly using XRP or USDC. Next check mark. Free. No fees to send or receive XRP or USDC to another Coinbase account. Next check mark. Global, available to Coinbase users in any supported country, including India, Mexico, and the Philippines. This is Coinbase promoting XRP specifically. So then, as XRP, shouldn't it just be a security of Coinbase? Right. They've got tremendous interest in this. And I'm being facetious, obviously. But you see, it's not Ripple that is promoting to the end user. The closest they ever got to that is when they gave away but did not sell to retail speculators. In the earliest of days, they were giving away XRP, but once XRP started trading and had an open market price, that no longer worked because you just give it away and then it just like tanks the price. You're like, well, you can't do that now. So, it wasn't the perfect distribution model, admittedly, and they know that as well. But hey, this is a brand new industry and people are just trying stuff. And who knew that an XRP would end up being worth the billions and billions of dollars that it is today. When you think about it, back in 2012, come on. So it's understandable that things haven't been perfectly smooth. That's forgivable in my mind. But wow, I think that's pretty strong. And then take a look at this from Modern Consensus. Here's a headline. Coinbase announces acceptance of XRP, Ripple ensues. And so I've always found it tremendously powerful that Coinbase, they met with the SEC, said, here's why we believe that XRP is not a security. We're going to list it unless you tell us that you think it's a security. And then they just didn't say it's a security. So Coinbase is like, okay, going to do it. Doesn't that mean something? Of course it does. Of course it freaking does. And then there was this. This is the SEC website, by the way. Securities purchase agreement by and between MoneyGram International and Ripple Labs, Inc. So that partnership dating over 3 years ago, this is June 17th of 2019, the SEC, not only were they aware of it, they approved of it. They literally approved of it. Why would they literally say, yeah, go ahead? Why would they say, yeah, go ahead and you can do this, have this partnership, if XRP is that much of a serious issue harming investors? Because if they're even a sniff of that being the case, the SEC never would have allowed this. Are you kidding me? Come on. They're not idiots, they're just bad people. They knew what XRP was back then. Of course they did. It's like, that's what I'm saying. If you're just an unbiased person coming into this, you're Judge Torres, and you're, again, unbiased person jumping into this, what the hell do you think about that? Anybody with half a brain is going to be like, yeah, that don't pass the smell test. And it sure as hell doesn't. And then there's utility. Like, I love all of these articles that were attached to, and again, all these are exhibits, what I'm highlighting, mind you. This is all from Attorney Deaton to Judge Torres, everything I'm showing you in this video. Then there was this from xrparcade.com. The XRP tip bot lives on through Uphold. And it's just amazing. I know it's shut down. Twitter ended up shutting it down, ultimately, the tip bot, even after it shifted to Uphold, but which I think is unfair, but it is what it is. Jack Dorsey was in charge at the time, and, he's Mr. Bitcoin Maxi and Lightning Network, even though it doesn't really properly work today, whatever, it is what it is. But you could actually send tips. It was changing the way that people moved value around the planet. Like, this is something that just wasn't possible before this technology, because the transactions were so cheap that they're almost free, substantially less than a penny. It's changing actual human behavior. There's utility to this. People value this. People want to be able to do this. And so, like, just want to ask, are you tipping people on Twitter or content creators with your Apple stock or maybe your Tesla stock? No? Oh, you're not? Because that's ridiculous as a concept? Yeah, I know. I mean, unless technically in the future, who knows, maybe things change. This is the caveat. Fine, maybe something changes in the future. You tokenize everything, and then it's effectively free to move all that stuff too, and people start treating that as money if regulations allow. Okay, fine. Maybe that's a fantasy that might happen in the future. But in the here and now, this is a cryptocurrency that's being used in place of money. In many instances, people were treating it as something of actual value because it is valuable, because people the world over decided it's valuable. Just like people decided that the United States dollar is value, even though it's not backed by anything. Just like humans decided that gold is worth something, even though gold's not backed by something. Humans are capable of deciding that things are of actual value without them being backed by other things. Go figure. And so is it so surprising that this can be done and humans do this? They literally do this and have for over a decade with cryptocurrencies. This is different. This is not a security just by the nature of it existing. I'm so glad the judge has seen this. Here's an article from The Block. Time Magazine now accepts Bitcoin and other cryptocurrencies for digital subscriptions. And I'll just note that this is Time Magazine accepting XRP and other cryptocurrencies, but XRP to pay for stuff. Again, I must ask, does Time Magazine allow you to pay for any sort of subscription service with your Apple stock or your Tesla stock. No? Oh, they don't? They don't allow. That's weird. That's super duper weird. Again, this is an entirely different animal. You can't today do that with stocks. You cannot. This is an entirely different, it couldn't be more obvious. And so for the SEC to try and do the, square peg round hole thing, it just rings hollow. And then there's this from QuipTorque, XRP directory, top companies accepting XRP. And so just in terms of payment, there's just a list of them here. There's 8 on the screen right here. Then there's this from Cointelegraph. Uphold's new debit card lets you pay with Bitcoin, XRP, and gold. Well, that's because it's being used as money by people because many people want to use it as money because it's valuable, because it has an open market price chosen not by some sort of dictator out there who controls XRP. It's been chosen by people on a global scale, not just in the United States, on a global scale. And the reason that we have an even playing field in terms of that is because there are cryptocurrency exchanges the world over and arbitrage exists. That's the reason. And so here you have another example of why XRP is functionally different than anything that was ever intended to be analyzed via the Howey test in that 1946 Supreme Court case. Then there's this. From The Block, Andreessen Horowitz-backed deal launches crypto payroll tool. And this is from November 11th, 2020, so a little more than a month before the S word hit the fan. And again, it's right, XRP's right here. A payroll platform which has drawn in $44 million in venture capital funding during the pandemic has unveiled a new tool to allow remote workers to be paid in cryptocurrency. Deal, which supports remote workforces with payroll and compliance, says the new tool will enable international workers to be paid in Bitcoin, Ether, or XRP with near instant withdrawals. So folks, if we get a poor ruling from Judge Torres, which I don't think is likely but could happen technically, you understand, like, the rest of the world ain't gonna give a damn. Maybe the price of XRP will go down instantly, but you would expect that, right? But then it would find a floor, just like always happens after scary news. And then since people are really building on top and value XRP because, and I say value, which is different than price, meaning they're using it, it would just keep trucking on. And then you just have this world where everybody, but except for people in the United States, get to use it because Ripple doesn't control it. It's decentralized. Wouldn't that be weird as hell if that actually happened? It's hard to imagine a world where that is allowed by Judge Torres. It'd just be offensive. And so I don't think that's going to happen, but I'm just saying. And then there's this from xrpl.org, powering innovative technology. And most of what they cite on this page isn't having anything to do with Ripple, most. It just shows what can be done with XRP and the XRP ledger. Look at this, micropayments, cryptocurrency wallets, exchanges, stablecoins, NFTs, DeFi, central bank digital currencies. They're talking about the private ledger there, admittedly. Then you got BitGo, asset custody, BitPay, payment processing, Coil, web monetization. We're talking about streaming money in real time utilizing XRP and the XRP ledger. You got gaming with Forte, GateHub, walled and platforms, Exodus, wallets and apps. You got Ripple, on-demand liquidity. So some of this is Ripple, but almost none of it. Toa Labs, infrastructure, raised in space, music, all using XRP and the XRP ledger. You got XRPL Labs, applications, including the Sum wallet. Explore, security. This is a global community full of people like you, people like me, also developers. There are speculators, everyone under the sun that you could possibly imagine. This is not Ripple's. This is not Ripple's property, damn it. They have the XRP they own, but they don't own the ledger. That is not theirs to register with any entity on the entire damn planet. It is not theirs. And Judge Torres is going to see every single thing I showed you in this video. It's an exhibit presented by attorney John Deaton. And he's the only one that did this, certainly to this degree anyway. My gosh. It's exhaustive and I love it. It needs to be, and it is, proving the points that he made in his amicus brief, which again I covered in a previous video. But man, that's what I'm saying. I'm optimistic justice will be done. It couldn't be more obvious what needs to happen here, could it? I'm not a financial advisor. You should not buy or sell anything because if anything I say are right, that would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.